We are present this morning in the matter of State of Ohio versus Tyler, aka Talia Karen. This is case number 24 CR 1412. President Open Court this morning is the defendant with her attorney, Rachel Smith. We were last here for a change of plea on October 23rd of 2025. At that time, the defendant withdrew her previously entered plea of not guilty, entered a plea of guilty to attempted aggravated arson, felony of the 3rd degree, and grand theft of a motor vehicle, felony of the 4th degree. This court set the matter for sentencing and ordered a pre-sentence report, psychological evaluation. Those were completed. We did appear for sentencing between that date and today a couple times. Both times, although we didn't go on the record, this court did continue the matter so that additional resources could be sought in regards to a potential outcome of this case for sentencing. Did have a chance to speak with defense counsel today and listen to the plan that's been presented. The state has also reviewed the pre-sentence report and psychological evaluation along with all the other documents presented in this case throughout the while this case was pending, and is prepared to proceed with sentencing at this time.
Okay. We actually are going to do sentencing first, and we'll address the registration afterward.
Okay.
So with that said, Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. On behalf of Ms. Karen, we are asking the court to impose a period of community control here. And Your Honor, we make that request without minimizing the seriousness of the offense here. Ms. Karen has pled guilty to setting fire to the home of her legal parents, and has been very forthcoming about her guilt in that regard from the outset. What has given defense counsel and I believe this court pause and allowed the matter to be continued multiple times ahead of sentencing goes a little bit deeper than the surface of the offense. Ms. Karen has a deep mental health history that the details of which I believe are currently being uncovered as this case has moved forward. Ms. Karen does have a history of seeking mental health treatment for PTSD, as well as several suicide attempts. And Your Honor, the impetus for committing the instant offense arose from pervasive and fixed beliefs that Ms. Karen has about her childhood and the role that her legal parents did play in that. Your Honor, Ms. Karen has no criminal history, did finish high school, is incredibly intelligent, has had no issues in the jail. She's pled guilty to a felony of the 3rd degree, and is in need of mental health treatment and is open to that treatment. In the past, Ms. Karen has been resistant to medications as part of mental health treatment, but she's expressed an openness and willingness to be medication compliant if medications are recommended as part of her treatment. Additionally, Your Honor, defense counsel has been working with Crossroads Behavioral Health representative, for which is present in the courtroom today, to facilitate Ms. Karen's admission into North Coast House. And it's our understanding that while at North Coast House, Ms. Karen's mental health needs will be taken care of, as well as wraparound services provided.
As well as what?
Wraparound services provided. Your Honor, we do believe that with the proper treatment and assessment, so long as Ms. Karen is willing to participate in that, will help to remedy the cause of what brought us here today. We don't believe that the public or Ms. Karen would be made safer if Ms. Karen is sent to a prison and without treatment. In fact, it's likely that her issues would become worse and she would exit prison on some date, a greater danger to herself and to the public. And Your Honor, for those reasons, as well as those that have been discussed throughout the pendency of this case, we are asking the court to give Ms. Coran credit for the days that she served in the jail, to grant her community control, and allow for her to participate in the program at North Coast House for mental health. Thank you.
In regards to North Coast House, we chatted in chambers about this. My understanding is, based on our conversation, they don't put a time period in place, though I was advised it would be at least 90 days. Can it be longer? And when I was advised it could be, but can I order a certain amount of time for that, or is that up to North Coast House?
Your Honor, I was able to ask Mr. Dials prior to coming on the record that very question, and he indicated that they would be able to comply with the court. If the court were to order a period of time, they would be able to comply
What
with
is
that.
the technically the range we're talking? I mean, what time periods could someone be there? Why don't you state your full name, please, for the record here?
Jamie Dials, Director of Forensics with Crossroads Health.
Is that DIALS?
DIALS.
Okay.
So we've never had a situation where an individual was court ordered to a specific amount of time. Typically the stay is 90 days, however, it's not uncommon for Crossroads Health to extend that time for various reasons until they maintain some form of mental health stability or until they find more long-term housing options. So in short, yes, we could honor.
What's the longest time someone stays there?
I bet.
I know there's no written rule on that regard, but in terms of if someone had the need that, the need that to be there, how long would you keep someone there?
So, for example, I also oversee Lake County Mental Health Court, and we've had individuals in North Coast House, and as a service, they would extend people's times there at North Coast House because of the immediacy of mental health court. I would say the longest that I'm aware of is probably close to 9 months.
Okay. Appreciate that. Member Smith, was there anything else? I'm sorry.
I don't believe so.
Ms. Karen, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
No, sir.
Well, there's a lot of people that put a lot of time and a lot of effort into trying to get you help instead of the alternative. Is this a waste of their time?
No, sir.
If I was to give you this chance, are you going to take it seriously? Are you going to work the program? Are you going to put forth the effort? Or is this just a way to avoid prison?
I will follow the program, sir.
The program requires that you take all medications as prescribed. Are you going to do that?
Yes, sir.
Is that going to be an issue?
No, sir.
Do you want this treatment program?
Yes, sir.
Do you want this help?
Yes, sir.
It's going to take some work on your part. It's not
I
just going
understand
to
that.
go there and everything's better. You know that. I know you know that. You're willing to put in that effort and the work?
Yes, sir.
And this is a big ask you're making here, or through your attorney, with the nature of the charges here. Ms. Smith, anything else?
Your Honor. That's Tim.
Mr. Downey for the state of Ohio.
Thank you, Your Honor. Before I say anything on behalf of the state, the defendant's parents, who are also the victims in this case, are present, and one or both of them would like to make a statement to the court, so defer to them.
Absolutely. And you could stand right there, sit whatever you're comfortable doing. State your full name, please, and spell the last name so court reporter can get it in. Take your time and tell me whatever you'd like me to know.
Cheryl Karen, it's K-A-R-R-A-N.
Stan, can you give a microphone, please?
Yes,
Hang on one second. You can just hold it down low. You don't need to talk right into it, but.
Test.
Yes, yeah.
Cheryl Karen, it's K-A-R-R-A-N.
Go ahead.
My husband.
Oh, yeah. What's his name?
Bentley, Karen, K-A-R-R-A-N.
Thank you both.
We just want you to know that we love Talia. This isn't behavior that we ever expected. And we support any help that she can get. We appreciate all the effort that everyone has made to help this happen. I don't believe that prison is going to help her at all, and I really think that Ms. Smith has been amazing. Sorry.
Sorry.
She's been really amazing at really working to get Talia the help that she needs. And we just want her to know that we love her, and we'll always be here for her.
Just Karen, anything you want to add? You don't have to. I just want to make sure. Okay. Thank you. Thank you both. One second, Mr. Downing. Mr. Downing for the state of Ohio.
Thank you, Your Honor. Clear that the defendant here is suffering from significant mental health issues that need to be addressed, and from the mental health side and the diagnoses that have been presented through the evaluations and the hospital records, it does appear that the treatment plan presented here does appear to address those issues. I think the difficulty for the state has been that the defendant also separately realizes that she committed a serious crime, and that crime was retaliatory in nature and unprovoked in the moment. She says in the pre-sentence report that she purposely went to the house to confront her parents, that after conversations with the parents, she was unsatisfied by their responses. She declined to leave the residence, and then waited till they were gone and decided to set fire to the home when there was no active threat against her at the time. At the time the pre-sentence report was completed, it did not appear that she had remorse for her parents. It seemed to be more remorse that she was caught and now in the criminal justice system. And even if the defendant's delusions here were in fact true, her conduct would never be justified. So certainly not legally, which is why there's not a legal defense here, but also morally. So it's from the state's perspective, what she did is just straight up criminal conduct. So I guess where the state struggles is then what is appropriate here, because her parents, the victims, want treatment. They've been extremely understanding and forgiving from the very start of this case when I first had contact with them. And I think that prison would certainly be justified here. I mean, the crime is serious. I mean, just the reduction here that the state gave to a felony 3 is pretty significant given the damage that was caused here. I mean, their home was destroyed and has to be completely rebuilt. I mean, hundreds of thousands of dollars of damage. If the defendant were to go to prison, she served a little over 9.5 months here. So the court has roughly 44, give or take, months to play with here for prison is what she'd be looking at, considering jail time credit.
Like 38.
36 from the felony 3 plus 18 from the...
Oh, I forgot about the other charge. Sorry.
And considering what was just said here today about North Coast House, I know I'm making a couple assumptions here, but she goes there and does treatment for 9 months where she's in a facility where she's not out in public. We're talking about, roughly about 3 years is what, if she went to prison, it'd be 3 years that she's away from society, right? So what is the right recommendation here? Prison for 3 years where we know that she is going to be away from society and is not going to be a danger to those around her. But in no way am I jaded and thinking that she's going to get the appropriate treatment in prison. And arguably, she might come out worse. However, given the nature of this offense, prison seems like the appropriate sentence from a punishment aspect. So, the mental health professionals and the treatment professionals that are here who have been involved in this case, they appear to be confident that the defendant can receive treatment that is adequate to not only treat the deep mental health issues, but also protect the defendant and those around her, in the sense that if she receives this treatment, then she will not commit further serious criminal conduct of this nature. And I'm not a mental health professional, so I have to defer to them, I think. Both of these options here, I think, seem pretty even when it comes to pros and cons. And the issues that the defendant has today that I think led to this seem to be something more recent. She has led a law-abiding life for a majority of her life. Best we can tell from looking at records and timelines is that at some point, this offense happened October 2024. At some point after January 2023, so about a 1.5 years, almost 2 year period, is when these more serious issues develop. So in terms of the defendant's entire life, this is something that's more recent. And when the defendant didn't have these issues or was receiving treatment or whatever she was doing before, she was safe and wasn't a danger to society. So based on what the mental health professionals have said, I have to think that if she were to get adequate treatment, that she would go back to that state. And from the start, the state has indicated that it would be amenable to treatment if an appropriate treatment plan was presented. So I'm going to go along with with the recommendation of community control, make that joint recommendation. I do so with a lot of hesitation. I know ultimately it's not up to me, it's up to the court. But I think the treatment plan should be done so with the understanding that if the defendant does not follow the treatment plan, then there will be very quick and serious consequences, which would be the termination of her community control in this case. I don't believe there's any restitution submitted from the victims here. The defendant does not have any money anyway, and given that it's her parents, I have not received any information from them about that, and so there's nothing further from the state this time.
Thank you. Well, I've considered the pre-sentence report investigation, the psychological evaluation. I received other evaluations that were done throughout the pendency of this case. There was a evaluation for NGRI that was done. We've had several hearings scheduled where we've talked and discussed this and continued the hearing to get more information. All that's being considered by this court. The victim impact statement, I've read and considered that. I've considered everything said here today by all the parties who addressed the court. I have considered the particular facts and circumstances of the offenses involved and the nature of those offenses, and I've considered all this in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912 indicating it's more serious, the court notes that the defendant's relationship with the victims facilitated this offense. The victim suffered serious psychological harm as well as economic harm. And then other relevant factors, it's destroyed their whole home. Most arson cases we have don't cause the damage that was caused here. Someone lights a small fire, there's a little bit of damage. That's what we typically deal with in an arson case. That's not what most people think about when they think about arson. They think about what happened here, quite frankly. But that's not the normal arson case. That's what we have here. As the prosecutor mentioned, it was retaliatory in nature, it was unprovoked. Those are all factors indicating it's more serious. Nothing makes it less serious. As for recidivism factors, the court notes there's no genuine remorse. It hasn't been shown. It hasn't been shown in the pre-sentence report. She feels bad for her parents, but then she immediately turns it around. And there's the mental health issues that are in play here. When she starts talking about the reason why she did this, and there's no remorse in that part of it. There's no remorse here. And given the chance today, she doesn't have to make a statement, but she didn't, and she didn't display any here today either. Factors indicating recidivism is less likely. There's no prior criminal history here at all. No juvenile delinquency adjudications, no convictions as an adult, law-abiding life. Her entire life, up until this. Other relevant factors indicating recidivism is less likely. I don't know if it indicates recidivism is less likely more than... obviously the mental health issues play a significant role here. If they can be addressed, then the hope is that would lessen the chance of recidivism versus the defendant, just being a bad person. I mean, obviously there's an argument that there's significant mental health issues that could cause there to be, recidivism could be more likely in the future. But with treatment, hopefully that can be addressed. The lesser included offense here of count 1 is a felony of 3rd degree. There's no presumptions one way or the other. Prison certainly is consistent with the purposes and principles of sentencing when you look at the nature of the offense involved. And that's been the court's struggle here, and that's, again, a lot of what the prosecutor said. The court's been struggling with those same issues in terms of just the nature of the offense itself. But due to the significant mental health issues that are in play here, though they don't amount to a defense, they certainly are relevant, are genuine, are significant. Also taking into strong consideration the victim's desires here, the court will find the defendants amenable to an available community control sanction. I'll give you a chance, but you're getting one chance here. This is a big opportunity. You should hopefully view it as an opportunity, not a break, but an opportunity that you're being given here. And there's a difference there. If you view it as an opportunity, hopefully you work at the program, put forth the effort. If you view it as just a break that you got lucky, then we're out of luck. I'm going to put you on community control sanctions for a period of 3 years. I am going to order that you serve 6 months on the lesser included offense of count 1 and 6 months in the jail on count 2. I'm going to run those consecutive for a total of 12 months. You have credit for 286 days. So a total of 12 months in county jail. I'm going to order that you enter the dual diagnosis programming at North Coast House as soon as the bed's available, and then get you in. As soon as that bed's available, you can be released from the jail. The balance of that 12 months will be vacated. So I just did that amount, so we have enough time to get you there. My understanding is it's not that, won't take that amount of time. Is that correct, Mr. Niles? You're going to enter North Coast House. I'm going to order for now for a minimum of 6 months. If we get to a point where it's time to be discharged and there's nothing more that can be done, something can be filed with the court, and I'll address that. But I'd like to put that in place now. Will that work, Mr. Dowles?
Yes, sure.
All right. To participate in the programming there, successfully ultimately complete that program. Further conditions, I want you to get a full psychiatric and psychological evaluation, follow recommendations. So recommendations for medication. Whatever medications are recommended, you need to follow those recommendations and take that medication as prescribed. If you don't, we'll be back here for a violation. You understand that?
Yes, sir.
In terms of psychological evaluation, follow all recommendations, which will include individual counseling, to include an EMDR therapy. I want you to participate in that. I want you to, further conditions, you're not to use any drugs or alcohol. That includes even marijuana. No marijuana use. Shall submit random urine screens when requested. They have to be negative. I want you to attend at least 3 AA meetings a week and have a sponsor. Ultimately, you're to obtain and maintain full-time employment or education. If you want to go to school, get some type of training, that counts as well. But on a full-time basis, you're ultimately going to be keeping yourself busy on a full-time basis, working or going to school or some combination of the two. You understand that?
Understood.
You're to utilize any case management services that are available with the treatment program for assistance and help, and utilizing the resources in the community. Prepare court costs and supervision fees. Follow registration requirements that are going to be provided to you here in a moment. I want you to sign whatever releases probation needs from you so that they can contact counselors or therapists if necessary. So you need to do that. You're going to have one doctor that can prescribe you medication. If there's specialists, that's fine as well. But make sure probation knows who the doctors are that you're getting prescriptions from. You can go get them from those doctors. You can only fill them at one pharmacy as well. Megan, is there anything else I should be thinking about here, considering?
No, Your Honor, thank you.
Lisa, anything else?
No, Your Honor.
Mr. Dials, have we covered everything we need to cover in terms of for the North Coast House there?
Yes, Your Honor.
Okay. Ms. Karen, you understand all the conditions of your community control sanctions?
Yes, sir.
Any questions for me?
No, sir.
Need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another criminal offense, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. Technically, I could impose more restrictive sanctions, including local jail time, or I can and will terminate your community control sanctions and send you to prison. If that happens, and that's what will happen if there's a violation, it'll be 36 months in the lesser included offense of count 1, an additional 18 months on count 2. That'll be consecutive for a total of 54 months in prison, which will also be consecutive to another prison sentence that you may be serving for some other case, if some other case happened, or that you're being sentenced to at that time. So do you understand all that?
Understood.
Do you have any questions for me?
No, sir.
In terms of sentencing, I know the registration, anything else that we need to address, Mr. Downing?
Yes, Your Honor. The victims indicated that they don't want a no contact order. They want to be able to speak with the defendant, have contact with her. However, they don't want her at their residence, either the residence in this case or the one, whichever residence they're currently staying at.
So you are not to, and I'll grant that as a condition of probation, you're not to go to your parents' residence, either the home where this happened or the home that they're currently residing at. You can have contact with them in terms of phone calls, letters, emails, texts, even seeing them if they come, but you can't be at the house. Is that what you're requesting? Be at the house, can't be where they're residing, you understand that?
Understood.
Ms. Smith, anything else as far as sentencing goes?
Not this time, Your Honor.
All right. Well, Ms. Karen, I need to advise you at this time, as you were told at the time of plea, you will be required to register as an arson offender. And I need to advise you of what those requirements will be. And then I'm going to have you sign this document indicating that, acknowledging I read them to you and you understand them. You don't have to necessarily agree with it, but you're acknowledging I read it to you. You're going to get a copy of this, so I'm not expecting you to memorize what I'm telling you, but I'm required to read it to you, so I'm going to do that at this point. So, do you have a middle name? Do I have that, or is that?
Do you legally, yes? Alexander.
I guess not.
Your Honor, the legal middle name is Alexander.
Alexander. I'm going to put that on here just for the form. And I'm going to use the address, expected residence address. I'm going to use North Coast for now. What is that address, Mr. Downs? We don't know.
Sorry, I don't know. I know it's in Concord now.
Nobody knows this address?
Is 255 Center Avenue is wrong, Joe?
Correct.
Okay.
Used to be.
That's just the Menor Avenue address.
It's moved from Menor Avenue recently. I can find out.
How can you find out? Just like texting somebody? All right, then I'm gonna go with these, and then we can just add that after. So your expected residence address, I guess at this point, is the North Coast House, correct? And
Understood.
after that, you don't have any plans at this point as to where you expect you would be residing, or do you?
No, sir.
Okay. Well, we'll use that address for now, and we'll give that, I'll get that here in a moment. But let me read you the requirements, your obligations you're gonna have. You've been convicted of, pled guilty to an arson-related offense. You will be required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from incarceration, or within 10 days of your sentencing hearing, if not sentenced to incarceration. So since you've been sentenced to incarceration, once you get out, you have to register with the sheriff's department within 10 days. That is at 84 North State Street in Painesville, and I'll read that to you later as well, and you'll have that, but that's where you're going to need to go to register. You will be required to provide the sheriff certain information, which will include your social security number, your full name and any aliases that you use, your residence address, information regarding the offense which you were convicted of, any description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you're employed or attend school, any driver's license number, commercial driver's license number, or state ID card number issued to you, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle information number, and a description of the vehicle must also be provided to the sheriff. You'll be required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your registration. You'll be required to remit a registration fee of $50 to the sheriff unless that fee is waived. After the date of the initial registration, you'll be required to re-register annually. You must update and or amend any of the information described above that is changed, and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. If you are registering in a different county than your prior registration, you must provide notice of your change of address to the sheriff with whom you most recently registered. You will also be required to pay a re-registration fee of $25 to the sheriff. Now I'm going to waive the initial $50 registration fee, and then the $25 re-registration fee. At that point, you should be working, and that should be assumed should be all right. So put in the entry that the initial registration fee of $50 is waived. Now you'll be required to comply with all the above described requirements until your death, unless your sentencing court determines otherwise. Since your expected residence address is in Lake County, you'll register in person no later than 10 days after you're released from jail with the Lake County Sheriff's Department at 84 North State Street, Painesville, Ohio, 44077. Your failure to register or failure to verify your residence at the specified times will result in additional criminal prosecution. You understand that?
Understood.
All right, do you have any questions at all about any of these registration requirements, what you're going to have to do?
No, sir.
All right, and I'm going to hand you this form right now. In line 10, it reads, I acknowledge that these requirements have been explained to me. I understand the requirements, and I must abide by them. And then I have you sign this again. It's acknowledging you understand it. So in line 10, I'm going to have you place your signature.
Your Honor, I have that address.
Now, give that back to me for 1 second, Stan, please. Let's get that on there first before she signs. What is it, Mr. Downs?
7480 Auburn Road, Concord Township.
44077 there, I think?
Yes.
Is there a phone number, or would that be the 241 number, or is that not? You don't know. That's all right.
Okay.
That's all right. All right, here you go. Mr. Karen, you signed the document?
Yes, sir.
I'm going to place my signature on line 11 now. That reads, I certify I specifically inform the offender of her duties as set forth above, as you indicated. To me, in understanding those duties, I place my signature. We'll have the bailiff make multiple copies. We'll get you a copy, your lawyer, the prosecutor, sheriff department. I think that covers everything. Mr. Downey, is there anything else that we need to address or should discuss?
So for the judgment entry, I was just putting there that the defendant was advised the arson offender registry acknowledged, signed open court, initial $50 fee waived. Is there anything else the court wants specific for that?
Initial $50 registration fee.
Correct, yeah.
It's hereby waived. No.
Thank you. Nothing further.
I did make that a condition of community control also to
Yes.
register.
Yeah, yeah. Thank you.
Ms. Smith, anything else?
Not at this time, Your Honor.
All rise. We are hearing case 25 CR 1297, State of Ohio versus Currency Fitzgerald. Present in court is the defendant, who's accompanied by his attorney, Mr. Corey Hinton. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, which would be amended to include both victims, and that is for aggravated robbery, a felony of the first degree, with the attached forfeiture specification as well as the 3-year firearm specification. Count 4, having weapons while under disability, a felony of the 3rd degree, and count 5, tampering with evidence, a felony of the 3rd degree. The state would move to dismiss the remaining counts of the indictment at the time of sentencing, and at this time there is no agreement with regard to sentencing. Thank you, Your Honor.
Thank you. Give me 1 second, please. All right, Mr. Hinton, does that all sound accurate?
Yes, Your Honor.
Mr. Fitzgerald, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here at this time?
Yes, sir.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to amended count 1, which would include both victims from count 2 as well, but it would only be 1 count.
Yes, sir.
The firearm specification included in that count, and you'd also be pleading guilty to count 4, weapons under disability, and count 5, tampering with evidence. All other counts would be dismissed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I'm going to ask you a series of questions. Excuse me. Now, if at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. All right, let's get started then. How old are you, sir?
17.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
No, sir.
You're not a U.S. citizen?
Yes, sir.
So you're a U.S. citizen.
Yes, sir.
Now, prior to coming to court here today, have you had any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication? Nothing?
No, sir. I got melatonin, but we waiting for it to come back in.
So you haven't had that in the last couple of days?
No, sir.
So nothing then?
No, sir.
Now, you would have received a copy, you should have received a copy of the indictment in this case sometime probably back in September of this year. That's the document that sets forth all the charges you're accused of committing. You remember getting that at some point?
Yes, sir.
And at some point, did you have the chance to look that over?
Yes, sir.
Now, in that indictment, you are charged with 8 charges, 8 counts. You're pleading guilty to 3 of those today. So I'm going to go over those charges with you. If you have any questions, make sure you ask.
Yes, sir.
But in count 1, as amended, what's alleged here is on or about July 29, 2025 in Willoughby Lake County, Ohio, that you did in attempting or committing a theft offense, or in fleeing immediately after you attempted or committed the offense, that you had a deadly weapon on or about your person or under your control, that being a firearm, and you displayed it, brandished it, indicated you possessed it, or used it. That conduct constitutes the offense of aggravated robbery. It's a felony of the first degree. Do you understand what you're charged with in pleading guilty to in count one?
Yes, sir.
Any questions for me about it?
No, sir.
The charge also carries with it a firearm specification that alleges during the commission of the offense you had a firearm on or about your person or under your control while you committed the offense, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm, or used the firearm to facilitate the offense. Any questions about that?
No, sir.
Now, the next firearm specification is being dismissed, but there's also a forfeiture specification which alleges during the commission of the offense you possessed or had in your possession a Glock 19 9mm firearm, magazines, and ammunition, which were used as instrumentalities. Instrumentalities are property that are used to commit an offense or to facilitate an offense.
Yes, sir.
And that's what it's alleged, that this firearm, the magazine, and ammunitions were possessed by you for. And the whole purpose of this is that you forfeit any ownership interest you have in that property. You understand that?
Yes, sir.
Any questions about that?
No, sir.
Now, the next count you're pleading guilty to is count 4, and what's alleged here and what you're admitting to is on or about July 29, 2025 in Willoughby Lake County, Ohio, that you, not having been relieved from disability in their operation of law or through legal process, knowingly acquired, had, carried, or used a firearm, and that you were under indictment for, or previously been convicted of, or adjudicated a delinquent child for the commission of an offense that, if committed by an adult, would have been a felony offense of violence, that being aggravated robbery, a felony of the first degree in Cuyahoga County Juvenile Court. That conduct constitutes of having weapons while under disability. It's a felony of the third degree. Do you understand what you're charged with in pleading guilty to in count 4?
Yes, sir.
Any questions about that?
No, sir.
Now, in count 5, what's alleged here and what you're admitting to is on or about July 29, 2025 in Maple Heights, Cuyahoga County, Ohio, as a part of a continuing course of conduct with offenses committed in different jurisdictions in which one or more of the offenses or an element of any one or more of the offenses occurred in Lake County, Ohio, that you, knowing an official proceeding or investigation was in progress, was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in the proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the third degree. Do you understand what you're charged with in pleading guilty to in count 5?
Yes, sir.
Any questions about that?
No, sir.
Now, there are 5 other counts of this indictment that are all being dismissed. Is that your understanding?
Yes, sir.
Any questions about any of those charges?
No, sir.
Well, now, before I can accept your guilty plea to the charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, or I would listen to the evidence and I'd make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means that all of them, all 12, would have to agree together, one way or another, as to each individual charge, whether you're guilty or not guilty. So all 12 would have to say guilty or not guilty as to each charge. You understand that?
Yes, sir.
Including the firearm specification. You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would represent the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges and specifications, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since it's a criminal case we're dealing with, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden we have in our justice system. What it actually means it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to do that, or at least to try to do that, if we were going to have a trial, the prosecutor would bring witnesses that come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
You realize you're giving up that right.
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
Give me 1 second, please. Well, do you understand do you understand all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. You understand them all?
Yes, sir.
Any questions for me?
No, sir.
Do you still want to plead guilty?
Yes, sir.
All right, give me 1 second. Do you understand that guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on a future day, be sentenced. I'm sorry.
Bless you.
Thank you. All right. Sorry about that. So again, let me repeat that. What pleading guilty and being found guilty means that you're be found guilty of the charge and that you will be sentenced as a result, which won't occur today but on a future date. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty in count 1 to a felony of the first degree. This offense is considered what we call a qualifying offense. That simply means it's a felony of the first or second degree that was committed after March of I believe it was 2018 or 2019. And what that means is that an indefinite sentence must be imposed by the court. If a prison sentence is going to be imposed, which it has to be because of the firearm specification. Indefinite means that there will be a minimum sentence and a maximum sentence imposed. In regards to the minimum sentence, the court will pick a number between 3 and 11. 3, 4, 5, 6, 7, 8, 9, 10, or 11. Whichever period I pick will be the minimum sentence you have to serve. The maximum sentence for that count then is determined by, it's a mathematical formula. You just take half of whatever the minimum is, you add that half to that minimum, and that becomes the maximum. So for example, if I choose 3,
Yes, sir.
half of 3 is 1.5. I'd add the 1.5 to the 3, and your maximum would then be 4.5. So it would be 3 to 4.5 years.
Yes, sir.
Another example, if I pick 6 years as the minimum, half of 6 is 3. I take that 3 and add it to the 6, that's 9. So your maximum will be 9, so it'll be 6 to 9 years. Again, hypothetically, if I took 11 years as the minimum sentence, which is the most I could take,
Yes, sir.
half of that's 5.5. If I added that 5.5 to the 11, that would become 16.5. So your sentence would be 11 to 16.5 years. Do you understand that?
Yes, sir.
Any questions as to how that works?
No, sir.
So for that particular offense, you face a maximum sentence of a minimum of 11 years, maximum of 16.5 years. Do you understand that?
Yes, sir.
Now this charge also carries with it a firearm specification, which requires the court to impose a mandatory prison sentence of 3 years, which must be served prior to and before you serve any other part of your sentence. Do you understand that?
Yes, sir.
So when I use the term consecutive, that means separate. You serve each term separately. You understand that?
Yes, sir.
Now, in regards to count 4 and count 5, the weapons under disability and tampering with evidence are both felonies of the 3rd degree. Each of those are punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, which is 3 years, or increments in between of either 12, 18, 24, or 30. So I'd select one of those numbers for each count. They can be the same, they can be different. That'd be the number of months you have to serve in prison for that particular count. Do you understand that?
Yes, sir.
Now, since there's 3 separate charges here, along with the firearm specification, as a judge, I do have the discretion to run the prison terms on the particular offenses concurrent or consecutive. As I said, the firearm specification has to be consecutive. It has to be served first before you serve any other part of any sentence. You understand that?
Yes, sir.
Now, in regards to the other offenses, I can run those prison terms concurrent or consecutive. Concurrent means together at the same time. You serve whatever the prison terms are at the same time. Consecutive, again, means one after the other.
Yes,
So
sir.
you'd serve, if I ordered them all consecutive, you'd serve the prison term for the firearm specification, then whatever I ordered for the weapons and disability, the tampering with evidence, and then you'd serve the indefinite sentence, whatever that is. You understand the difference there?
Yes, sir.
Any questions about that?
No, sir.
So I'm required to make sure you understand the maximum sentence you face by pleading guilty. And if I gave you the maximum sentence for each particular count that I just reviewed with you, along with the firearm specification, and I ran everything consecutive, you're looking at an indefinite prison term of a minimum of 20 years with a maximum of 25.5 years. That'd be the maximum sentence you face, 20 to 20.5 years. 20 to 25.5 years. You understand that?
Yes, sir.
Now, do you have any other charges pending against you right now?
Your Honor, he does. There's a case in Cuyahoga Juvenile Court that resulted from the search warrant that was executed in connection with this case. I know he, through his mother, has been in touch with the court or prosecutor in that regard. There's another pending case from Kent as well. So those 2 cases are pending, and he may be on...
And the Kent is in Portage County, is that Portage?
It is.
That's in juvenile court also?
It is.
Your Honor, the Kent case was actually transferred to Cuyahoga County as well.
Correct.
Okay. But Cuyahoga Juvenile Court?
Cuyahoga County Juvenile Court, yes.
Are they attempting to bind any of those over to adult common police court?
I don't know the status of those.
I know he had a prior adjudication in Cuyahoga Juvenile Court, but he doesn't believe he's on probation for that.
Or any type of parole or supervision or anything?
No, sir.
The reason I ask about other offenses, I don't think it's going to be applicable here, but if you get sentenced to prison on another case before you come back here for your sentencing in this case, I could run a prison sentence in this case concurrent or consecutive to that.
Yes, sir.
But I can only do that if it's already been imposed. If it hasn't been imposed yet, I can't order like my sentence be consecutive to some possible future unknown sentence that may happen. I can't do that. It's
Yes,
already
sir.
got to be imposed. You understand that?
Yes, sir.
Now, if I were to sentence you to prison and you ultimately got convicted of other charges in adult court, that judge can run them consecutive to my sentence. But I don't have any say or any authority to do that
Yes, sir.
ahead of time. You understand that?
Yes, sir.
Okay. In this case, upon your release from prison, you would be placed on post-release control, which is sometimes referred to as parole, or PRC. It's a period of supervision you would be on after you serve whatever the prison sentence is. And in this particular case, it's mandatory for at least 2 years, and it could be up to 5 years. It's up for the parole authority to decide exactly how long, but it would be at least 2 years up to a maximum of 5 years. Do you understand that?
Yes, sir.
And if you are on post-release control and you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, going back to the indefinite sentence for count 1, the aggravated robbery charge, I explained there's a minimum sentence and a maximum sentence. Remember that?
Yes, sir.
In regards to that, there is a presumption that you will be released after you have completed the minimum sentence for that particular count. Now, you have to do the firearm specification first, and if there's any consecutive time, that would all have to be done first. But then once you start serving the indefinite sentence, there's a presumption that you would be released after you serve whatever I ordered to be the minimum sentence for that count. You understand that?
Yes, sir.
And what that means is that you would have to be released from prison unless prison officials schedule a hearing because they believe that you shouldn't be released yet, that while you have been in prison you haven't followed the rules, you're not sufficiently rehabilitated, you remain a threat to the community or society. If they believe that and have a hearing and make that ultimate determination, then you won't be released at the minimum sentence. They'll keep you in prison. They'll pick a new date that it is that you're to be released.
Yes, sir.
And you have to be. There's a presumption you'd be released on that new date, unless again you continue to misbehave or continue to be a threat or not be rehabilitated. And if at a hearing that was established again, they can keep you in again longer. You understand that?
Yes, sir.
Under no circumstances, however, can you be kept in beyond the maximum sentence for that particular count. So, whatever that maximum sentence is for that count, you'd have to be released. Even if you misbehaved every day you were there, they'd have to release you after you serve the maximum sentence. You understand that?
Yes, sir.
Now, you would also have the right, since this is not a mandatory sentence, that the firearm specification is mandatory. But once you've served that, you will have the ability to earn what is called good time credit based on good behavior.
Yes, sir.
It's not automatic, it's not guaranteed, but you will have the ability to earn that. And there's a presumption that if you do earn it, that you will be awarded that time. The only way that wouldn't happen, the prison officials will be required to notify the sentencing court, me or whoever's sitting in the seat at that time,
Yes, sir.
that you've earned this credit. And then the judge can disapprove that if the judge wanted to do that. If the judge doesn't do anything, it gets approved automatically. If the judge wants to disapprove it, then he has to schedule a hearing and bring you back for that hearing and have a hearing to determine whether it should be approved or not. You understand that?
Yes, sir.
All right. Now, aside from the prison term I just mentioned, there's other sanctions that could be ordered. You could be fined. The aggravated robbery charge carries with it a possible fine of up to $20,000. The other two counts carry possible fines of up to $10,000. So altogether, if I find you on each count, it's up to possibly $40,000 in fines. You could be ordered to pay court costs and also ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable in this case. Do you understand that?
Yes, sir.
Also, you will forfeit any right, title, or interest you have in that property, as I mentioned earlier. The firearm, the ammunition, and the magazine will be forfeited in the state of Ohio. Do you understand that?
Yes, sir.
Lastly, the court also can order or will order restitution for any economic loss any victim may have suffered as a result of the criminal conduct involved. You understand that?
Yes, sir.
Now, as I mentioned earlier, when I was explaining the prison terms, the firearm specification requires that a mandatory prison term be imposed. That means at the time of sentencing, I will not be able to consider community control sanctions or probation. You have to be sent to prison. You understand that?
Yes, sir.
Now, while you are in prison, after you have served any mandatory prison term, you would be eligible at some point to request what is called judicial release. That is a motion that you would make with the sentencing court requesting to be released from prison early and put on probation. Now, you're only eligible for that when you're serving non-mandatory prison sentence.
Yes, sir.
The only mandatory prison sentence here is 3 years for the firearm specification. So once you start serving any sentence after that, you could start becoming eligible for judicial release. Your eligibility depends on whatever the sentence is, how long the sentence is. Depending on how long it is, will dictate how long you have to wait before you can make that request and become eligible.
Yes, sir.
So the longer your sentence is, the longer you have to wait before you can become eligible. But at some point you would become eligible. Do you understand that?
Yes, sir.
Now, just because you're eligible for judicial release doesn't mean you get it. It means, all that means is that you can request it of the court, file a motion, and the court will consider it. You understand that?
Yes, sir.
Lastly, when we do proceed to the sentencing hearing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't find that that's the right thing to do. Do you understand that?
Yes, sir.
All right. Will you have any questions at all then regarding potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer and have him review the reports with you, discuss the issues, and answer your questions?
Yes, sir.
You've had enough time to talk with him about everything?
Yes, sir.
Are you satisfied with his advice and counsel?
Yes, sir.
Has he or has anyone made any promises to you about what's going to actually happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced by anyone to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily? Is this what you want to do?
Yes, sir.
All right, then, Mr. Fitzgerald, any questions for me at this time regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with the actual plea?
No, sir.
Very well, then, at this time what's going to happen here is the prosecutor here is going to explain for me what she believes the evidence would show at a trial if we did have a trial. I want you to listen to her and what she has to say, because then I'm going to have some questions for you about that, all right?
Yes, sir.
All right, Simline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on July 29th, 2025, at the Willow Park Apartments located in the city of Willoughby, Lake County, Ohio, the defendant, his brother Denaro Logan, Joseph Smith, and a fourth male went to the Willow Park Apartments in response to a Facebook Marketplace ad from Jonathan Hernandez. Jonathan was selling a Cartier Moissanite watch. When the three males arrived, they exited the vehicle, that being the defendant, his brother, Denaro Logan, and Joseph Smith, brandished weapons and robbed Jonathan Hernandez of that Cartier Moissanite watch. They also robbed his brother, Enrique Hernandez, of a firearm that he had on his person, that being a Sig Sauer P365XL 9mm, serial number 66B632569. They did so without the consent of Jonathan or Enrique Hernandez. The three males got back into the vehicle and left. A BOLO was issued for the vehicle. The vehicle was located by the Bedford Police Department. The vehicle fled when Bedford attempted to stop the vehicle. When the vehicle was ultimately stopped in the city of Maple Heights, the defendant did flee from the vehicle. In the area where he fled, police located a loaded Glock 19 Gen 4 model 9mm firearm with magazine and ammunition. That serial number is BMBG231. And a little further away, a neighbor had also located a red Cartier moissanite watch box in their yard. The defendant does have a prior adjudication for a juvenile adjudication in Cuyahoga County, case number DL23107779, dated November 2nd, 2023, and that was for aggravated robbery, a felony of the first degree with a 1-year firearm specification, and grand theft, a felony of the 4th degree. Thank you, Your Honor.
Thank you. Mr. Fitzgerald, have you, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we did go forward with the trial?
Yes, sir.
What, if anything, do you have to say about those facts as she just presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1 as amended, charging with aggravated robbery involving both victims, a felony of the 1st degree, what is your plea to that?
Guilty.
As for the firearm specification, the 3-year firearm specification, what is your plea to that?
Guilty.
As for the forfeiture specification, what is your plea to that?
Guilty.
As to count 4, charging with having weapons under disability, a felony of the 3rd degree, what is your plea to that count?
Guilty.
And lastly, as to count 5, charging with tampering with evidence, a felony of the 3rd degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and what it says, and that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Mr. Hinton, is that accurate? Did you review this with Mr. Fitzgerald, read it over with him, answer all his questions?
Yes, Your Honor. Prior to today, we did sit down and go over it. I read the entire document to him. I provided him with a copy of it, and then I was able to touch base with him on it again this morning in court.
Did he indicate an understanding of the contents of that document to you when you went over it with him?
Yes.
Is that correct, Mr. Fitzgerald?
Yes, sir.
So you understand what this document says?
Yes, sir.
Do you have any questions for me about it?
No, sir.
Now, it does appear that you signed it a couple times. Did you in fact sign it?
Yes, sir.
And you witnessed that, Mr. Hinton?
Yes.
And Ms. Himmeline?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court further finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of amended count 1, aggravated robbery, a felony of the 1st degree in violation of 2911.0181, along with the 3-year firearm specification, that's the first specification, and the forfeiture specification. I also find the defendant guilty of count 4, having weapons while under disability, a felony of the 3rd degree in violation of 2923.13A2, and count 5, tampering with evidence, a felony of the 3rd degree in violation of 2921.12A1. The remaining counts and specifications of the indictment will get dismissed at sentencing. Sentencing will be deferred. I'm going to order a pre-sentence report and investigation and victim impact statements. I think that covers everything. Is there anything else for the record, Ms. Himmeline?
Just with regard to housing, Your Honor.
Okay, go ahead.
The state would make an oral motion to transfer the defendant to Lake County Jail. So he's presently being detained at the Lake County Juvenile Detention Facility. Upon entering a guilty plea under 2152.02, the defendant is no longer considered a child under the eyes of the law, and the state is asking that he be transferred over to the Lake County Jail to await sentencing.
Is that mandatory or required, or is that discretionary?
It's discretionary. So 2152.02C7 states that upon either conviction or pleading guilty to a felony in adult court, the juvenile loses that status, and that's also reiterated in 2152.02C5, but there is no requirement that the court.
Is that, the juvenile court judge doesn't have that
Correct. So the
authority.
juvenile, when a case is bound over, the juvenile court does retain jurisdiction to determine where the defendant would be
Remember, we
housed.
discussed this at the pretrial.
Right. And so now, upon entering the plea of guilty, that divests the juvenile court of that remaining jurisdiction and puts that now within the jurisdiction of this
So
court.
I wanted to make sure I wasn't stepping on anyone's toes or anything. like that.
Correct. 2152.02C5 specifically states that upon a plea of guilty, quote, the defendant shall be deemed after conviction, plea, or invocation not to be a child in any case in which a complaint is filed against the person.
Okay. Mr. Hidden, did you want to be heard in this?
Thank you, Your Honor. As to this issue, and speaking with Mr. Fitzgerald, he would like to remain at the Juvenile Detention Center. He's on level 4, which my understanding is a good thing. It means he's behaving there. I know initially when we were addressing this case, at one of the first hearings, there was an indication that when he first got into the detention center, that wasn't necessarily the case, but I haven't heard anything that he's misbehaving over there. I believe he's following all the rules, not losing points. Even though he was bound over as an adult, he is 17. I know at the detention center it's a bit easier for him to communicate and have contact with his mother. I know she just went over and spoke with him yesterday. I don't know if it was in person or on the phone, but spoke with them about the change of plea process and that sort of thing. I know that he's been there for a while. He's comfortable over there. I think that it would make sense, and it would be our desire to keep him in the detention center until he's sentenced. He knows that he's going to be sentenced to prison, but my understanding is if he goes over to the jail that he's isolated from the adults, and I believe he basically sits in a room with a TV.
Okay,
So
well, I'm sorry.
I think that when he's over at the detention center, they're doing a lot of things as far as going to school during the day and things of that nature. So I think that that would be better than him just sitting in a room by himself. We certainly respect the decision of the court, but that is our thoughts on it, Your Honor. Thank you.
Well, in this court's view, he should have been in the jail since this happened. He's being treated as an adult. He's going to be treated as an adult, so he's going to be housed in the Lake County Jail. Anything else for the record?
No, Your Honor. Thank you.
Go ahead.
Your Honor, as far as the pre-sentence report, I know that probation's not on the table, but if the court during the pre-sentence report would order a mental health evaluation, that may be useful to the court in trying to gather facts regarding the defendant for purposes of the sentence.
I'm not necessarily opposed to that, but won't I have that? Isn't there a lengthy evaluation that was done in juvenile court or not? Or was this a mandatory evaluation?
This is a mandatory, so there was no
All
amenability.
right, my fault. Then yeah, I'll order a psychological evaluation.
Thank you, Your Honor.
Yeah, the only reason I did it was I was thinking that there was one from juvenile, which I'll have the ability to read, but if there wasn't, we'll do it.
Okay, thank you,
Got
Your
that,
Honor.
Stan? All right.
Ohio versus William Edmondson. This is case number 25CR001271. There was a two-count indictment filed on October 10th of this year, alleging count 1, possession of cocaine, and count 2, possession of cocaine. Those both being felonies of the 5th degree in violation 292511 of the revised code with accompanying forfeiture specifications. Subsequent to that being filed, the defendant filed a motion for intervention in lieu of conviction, and that was referred for evaluation. We're here today to address that particular motion by the defense, and the defendant is present with his counsel, Mr. James Reardon.
Thank you. Mr. Reardon, what, if anything, would you like to say on behalf of the motion, your motion here?
Thank you, Your Honor. As the court is aware, the motion was filed by my client's predecessor counsel. I was hired only after Mr. Edmondson's bond was revoked for the positive marijuana. However, leading up to today, I've had the opportunity to review the pre-sentence documents or the documents created as a result of the motion. And I understand that the evaluator has indicated that Mr. Edmondson is eligible for intervention, and of course I'm encouraging the court to accept that recommendation. At the same time, I also reviewed and understand that Mr. Edmondson himself, when he was interviewed, discussed the facts and circumstances at hand, of which, I explained to the court that Mr. Edmondson and I discussed the matter today, and without prompting, Mr. Edmondson told me about, I've got a problem and here's what I'm doing about it, and if I tell this to the judge today, is this a good thing, for me to explain to him where I'm at on all this? And of course I said, yeah, it's a great idea. Tell him what you're planning to do and what you're going to do to address the problem. So I know the court is concerned about Mr. Edmondson himself, being forthcoming about his problem, and I think he's going to tell you point blank he has a problem and he wants help and he's hopeful, and I'm urging the court to grant the motion.
Well, Mr. Edmondson, your lawyers have filed what's called a motion for intervention in lieu of conviction, and I'm not sure if you know exactly what that entails. If you do and if you had that discussion, then you'll have to bear with me and hear it again. But a motion for intervention in lieu of conviction is when a person files a motion saying they've committed a crime because they're drug dependent. And you're asking to be put on a period of rehabilitation to get help. And if you successfully complete this rehabilitation, the charges get dismissed. That's a pretty big deal to not have a felony conviction on your record. And these motions don't get treated lightly. Take them serious. So there was a motion was filed. We sent it to get referral to get these reports prepared, and the reports have been completed. I guess I want to hear from you and hear why you think that this, this extraordinary remedy, quite frankly, should be granted to you in this case. What your thoughts are here? Because I've read what you said, the probation. But,
yes, Your Honor. I made some bad choices the past couple of years, and I broke the law.
How'd you break the law?
By using and hiding, and I let people down. I was hiding my addiction.
What addiction?
I was doing cocaine, smoking crack for the past couple of years.
How often?
A couple times a week, probably.
That's more than 3 times a year that you told the probation department.
Yeah.
3 times a year you told them you did that.
I told them on festivities, things like that.
I'm sorry?
On festivities and
But you said you've only used cocaine 3 times a year. Now you just told me you do it a couple times a week. There's a difference between, that's 108 times, 104 times a year versus 2 times a year.
I know.
So which is it?
I was using a lot. I was using a couple times a week.
So why weren't you upfront with them?
I was scared. I
know that's the truth. Everybody in here knows that's the truth.
Since I moved back to my hometown, I have a new job and whatnot. And I've been back to my home group, my AA home group.
What's your new job?
I work for Actor Technologies.
Doing what?
I'm working security and construction.
When did you start this job?
Back in September.
So why didn't you tell probation about this job?
I did. Well,
No, you didn't.
Chase and Hannah Properties is the same business. Same owner, same business.
You sure about that?
Yes, sir.
What do you do?
I for circuit boards for entropy-based systems, like it's for health and fitness and building constructions.
You don't know what it is, do you?
Yes, I do. Yes, sir.
You've really been doing this job?
Yeah, just for the past couple months, past month and a half.
Why didn't you tell probation about it?
Well, it's the same thing as Hannah Chase Properties. I'm a rebuilder, renovating building properties. And he has buildings there that I've been building, like lab. I'm really nervous, but like lab desks and things like this, where they put
It's time to be honest about what's going on here, Mr. Evanson.
I'm being honest, sir. I really am.
This is not some just job that your friend just
No.
wrote up for you and said you got this new job, this great job?
No, I've been building and being a builder with him, renovating properties since I lost my last job.
What last job?
I work in a Midwest box company. I lost because of my addiction.
If this is the approach you're going to take throughout this, you're going to be failing at this pretty quickly.
I promise you I won't fail, Your Honor.
No, then you need to promise that you're going to tell the truth. You do know that all your messages and stuff are accessible to people to look at, right?
Certainly, yes.
Mm-hmm. So you want to reconsider this job thing that you're telling me about?
I work for, I was working for Hannah Chase Properties. My friend owns it, and we're doing construction.
What about this? What's this extra, whatever you're talking about?
Electricore.
It's nothing, right?
No, it is a business.
That's a business. I know it's a business. It's a business that you have nothing to do with.
Not yet.
Oh boy. So how are we supposed to know if you're telling the truth or not?
I'm telling you.
Met with probation, told them you use cocaine 2 times a year or 3 times a year. Don't mention anything about this business. Come in here, you start talking about a business, tell me you've worked there since September. Now you acknowledge that no, you're not working there yet. And then you come in and tell me that you're using cocaine 2 times a week, which I believe that. You're saying what you think I want to hear instead of telling me just the truth about stuff.
Your Honor, if I may.
Sure.
I mean, I'm just picking up the letter from...
I wouldn't go there, Mr. Reardon, but all right.
Well, I get it. Look, all I can say is from my 30-plus years' experience, I mean, Mr. Kelly, who obviously is his friend, has gone out on a limb to find me, hire me, ask me to help this guy, you know, is vouching for his ability to be a decent human being. I do believe fundamentally that is possible. I do. And I think the guy...
He's also writing a letter telling me that this guy works for him, and he...
I think
that's not true.
I mean, I don't know the details of that situation other than I think he's his friend and I think he's going to help him, which I think that if it's in the parameters of a treatment program, et cetera, he'll have flexibility to do what he needs to do to address his main problem first. I mean, that's my only 2 cents on the subject is I don't get a lot of people... I mean, I get moms and dads that hire me, of course. I don't get a lot of 45 years friendship guys who go out on a limb to hire a lawyer for their buddy. So for whatever that's worth, which I think is worth something.
But he's going way further than a limb. He's lying, a friend.
I can't comment on all
I'm
those
not-
details.
I didn't ask you about it.
Yeah, I
That's why
know,
I told-
because I don't know them. All I know is what I believe is a guy who's truly gonna help his friend and has the ability to
I
do
don't know,
so.
I guess it depends on how you define help. You know, if helping is the right to a judge to tell a judge that this guy's got this great job that he really doesn't have, so he can get out of jail. Yeah, I need to take a brief recess here. to step off the bench here for a moment just to cool down a little bit. You know, Mr. Edmondson, when you look at your report and all the history, you're clearly an appropriate candidate for intervention in lieu of conviction. You've got a drug problem. Even if you don't recognize it, everyone else recognizes it. You acknowledge it here today. You don't have a criminal history, a horrible driving record, but you don't have a criminal history. If you would have gone to probation and been honest with them about your issues and other matters, well, frankly, it's been a no-brainer. But then you go there and lie and mislead them. Try to put yourself in a better light. And I get that in one sense, but when you talked about the offense itself, you're trying to make it look like this is some old cocaine from a long time ago. You haven't been in this car for a long time, and it's old. You completely forgot about the fact that you had it in your hand when you emptied your pockets. So when I start considering that part of it, I think, well, maybe he's not going to be a good candidate for this, because intervention in lieu of conviction is not going to work if you're not going to be upfront and honest with your probation officer and work with them. If we're doing this, it's because everybody's working to try to get you help that you need. But if in probation, I mean, this is the last time you're going to see me, hopefully. But you'll be meeting with probation a lot. And they'll be happy to meet with you and work with you and try to help you if you're doing what you're supposed to be doing. But if you're going to lie to them, it's not going to work. And then they're going to lose their interest in doing that. They'll do their job. But they're not going to be going out on a limb for you if you're not going to be open and honest with them. Now, if you want this help and you want to stop using cocaine and stop this life, and you're willing to do that, it's a good program. Because you can not get rid of a felony conviction and not have it on your record. You don't have a felony conviction. Assuming you don't want one now at age 50, what, 54? 53, 56, what did you say?
56.
But if this is going to be the way you're going to conduct yourself and handle yourself while you're on probation and lie to them and misrepresent to them, and if things aren't going well, try to hide things from them, and you're going to be right back here for a violation. You're going to have a felony conviction, and there's a much better chance you're going to go to prison than at that point. Which, you shouldn't go to prison for this. I'm not going to send you to prison today. Even if you didn't have this, I wouldn't send you to prison today. But if you continue acting like this, that's where it's going to end up. So you're going to be able to do this without playing games with probation, without playing games with the court, with being honest with the people?
Yes, Your Honor, I promise. I will. I'll be honest.
You gotta make these decisions yourself. I don't know who this person is and this friend, and maybe he's a longtime friend, and I'm not questioning what Mr. Reardon said, and I'm sure he's acting to try to do to help you. But the route he took, you think it's helping you, but you gotta be able to stand up for yourself and stand up on your own and do what's right.
Absolutely right.
Well, I'll give you a chance at intervention in lieu of conviction.
Thank you, Your Honor. I won't let you down. I won't let myself down. I promise.
Fine, you're eligible. Before I can officially grant it, you need to plead guilty to the 2 charges. We'll just do the paperwork in the course of it. You don't need to do it now.
Okay.
And before I can accept your guilty plea, I need to make sure you understand everything going on here. So I'm going to have to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand what's going on, all right?
Okay.
Sorry?
Okay, yes.
Let's get started then. How old are you?
56?
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
Nothing, no.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you should have received a copy of the indictment in this case. I know you got it sometime back, probably around October, which sets forth the 2 charges. You remember getting that?
Yes.
At some point you had a chance to look at that?
Yes.
Now, in that indictment, you're charged with 2 counts. Of possession of cocaine. I'm going to go over those with you to make sure you understand them. If you have any questions, make sure that you ask. But in count 1, what is alleged here and what you'll be admitting to is on or about, quite frankly, both counts are the same. It's just 2 separate amounts of cocaine. In both counts, what's alleged is on or about August 25th, 2025 in Willowick, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to counts 1 and 2?
Yes.
One count deals with the cocaine that was in your hand that you took out of your pocket. The other one deals with the cocaine that was in the front seat. Was it in a bag, I think, if I'm remembering correctly, Ms. Linden?
There's a plastic bag, Your Honor, and a plastic container.
So that's the 2 separate counts. You understand that?
Yes.
Any questions about these charges?
No.
Each count also carries with it what's called a forfeiture specification, which alleges that you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just because of the nature of the property, whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner. You can't possess it for that purpose. And here it's alleged there's the cocaine itself, along with plastic containers and a pipe. The whole purpose of this is that you forfeit any ownership interest you have in any of that property and allows the state to dispose of it at the conclusion of the case. You understand that?
Yes.
Well, then, before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial, which a trial could be to me as a judge, where I listen to the evidence and make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each charge. You understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial?
Yes.
If we had a trial, you'd have to have a right to have an attorney represent you. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent, again, of the charges, and the presumption sticks with you and stays with you until the state is able to present enough evidence, if possible, to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, I speak of this burden of proof since this is a criminal case. The burden of proof is what we refer to as proof beyond a reasonable doubt. It's the highest burden there is in our justice system. What that means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of these charges beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that, the prosecutor will call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask them questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to, and to answer your lawyer's questions. So you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if you went to trial and you were found guilty, you would have the right to appeal that guilty finding. However, by pleading guilty here today, you're not going to be found guilty, so there's no issue on appeal at this point. But if you were to violate the intervention plan, the treatment in lieu of conviction, you would be found guilty of the charge at that time. By pleading guilty, you're giving up a right to appeal that going forward, or any other issues you could have raised. You could appeal the reason why you violated if you felt that wasn't warranted. But ultimately, the finding of guilty by pleading guilty and any other issues you could have brought to my attention up to today, you're waiving the right to do that. You understand that?
Yes.
All right. Well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you would normally be found guilty and then be sentenced. What's going to happen today is I'll accept your plea, but I won't find you guilty. I'll issue what's called a stay of criminal proceedings, which means you're not going to be found guilty, you're not going to be sentenced. I'm going to put you under the supervision of the probation department for a period of time, and I'm going to implement an intervention plan with certain conditions and treatment to get through. If you do that and successfully complete it, the case gets dismissed. If you don't, there'll be a motion to terminate your intervention in lieu of conviction that gets filed. And if it's found that you did in fact violate, I will vacate or lift that stay of criminal proceedings. I'll find you guilty of the charge and we'll proceed to sentencing. Now obviously the hope is that we don't get to that point, but I need to make sure you understand what that potential penalty could be if that were to happen. So I'm going to review those potential penalties with you. Again, we're not planning on going there, but I need to make sure you're aware of what that could happen. And since there's two charges here, they're both felonies of the 5th degree. They're each punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
And since there's two charges, if I did impose a prison sentence, I would do it on each count. Then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means same time. You serve them at the same time. Consecutive means one after the other. You serve the prison term on the first count, complete that, then serve the prison term on the next count. You understand the difference there?
Yes.
So in this case, if I give you the maximum prison term on each count and ran them consecutive, you're looking at a maximum prison term of 2 years in prison. You understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
You have any other charges pending against you right now anywhere?
No.
If a prison sentence were ever imposed upon your release from prison, you could be placed on what's called post-release control. It's sometimes called parole, which is a period of supervision you would be on after you serve the prison sentence. And in this case, it could be up to 2 years. Do you understand that?
Yes.
And if you're ever on post-release control and violate any of the conditions of your supervision, you're going to be placed on what's called post-release control. It's sometimes called parole, which is a period of supervision you would be on after you serve the prison sentence. And in this case, it could be up to 2 years. Do you understand that? Yes. And if you're ever on post-release control and violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered if we ever proceed to sentencing. Some that will. You will have to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes.
You will also forfeit, as I indicated earlier, any ownership interest you have in the contraband and instrumentalities. Do you understand that?
Yes.
Now, in regards to other potential penalties, there could be a fine imposed if we proceed to sentencing of $2,500 on each count. So that's a maximum fine of $5,000. And I could also suspend your driver's license if we ever proceed to sentencing for up to 5 years. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you would face if we ever proceed to sentencing. I used the word possible. Prison wouldn't be mandatory at that point. You would still be eligible at that point for probation or what's called community control sanctions. Just because you would be eligible doesn't mean you would automatically get it at that point. I would look at everything that's going on, particularly why we're back here again and you're violated, and make the decision that was right. Do you understand that?
Yes.
Now, if you are put on community control sanctions, it could be up to 5 years, and as a judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes.
Further, if you're on probation, you ever violate the conditions of your supervision, there'd be a hearing to see if you're a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it then, again, it could be 6 to 12 months on each count, consecutive for up to 2 years, which could also be consecutive to any other sentence you may be serving for something else or that you're being sentenced to at that time. You understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face if we ever did have to proceed to the sentencing hearing?
No, Your Honor.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer your questions?
Yes.
Are you satisfied with his advice and counsel?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you entering a guilty plea freely and voluntarily?
Yes.
Do you have any questions for me at this point regarding anything we've just discussed?
No questions, Your Honor.
Do you need any more time to talk to your lawyer?
No.
Then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'll have some follow-up questions for you, all right?
Okay.
Swindon?
Your Honor, had we proceeded to trial, the state would have submitted evidence to show beyond reasonable doubt all those facts and elements that are outlined in counts 1 and 2 in the forfeiture specifications. This was a result of a traffic stop. As a result of the traffic stop, there was a K-9 that ended up coming and alerted. And in this case, the defendant had 0.31 grams of cocaine scheduled to tested by the Lake County Crime Lab, and the other amount in the plastic bag container pipe that was cocaine residue tested by the Lake County Crime Lab.
Thank you.
Thank you.
Mr. Edmondson, were you able to hear what the prosecutor said regarding what she believes the facts would show if we had a trial?
Yes.
And what, if anything, you have to say about those facts as she presented them? Are they true? Did you do what she said?
True.
Very well, then, regarding counts 1 and 2, each charging with possession of cocaine, each felony is of the 5th degree, each with a forfeiture specification. What is your plea to each of those 2 counts?
Guilty.
All right, you have in front of you there a 4-page document. You got the correct one there, Mr. Reardon?
I do.
Okay. It's called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your guilty plea, I need to make sure you understand what that document says and that you sign it here in open court. My understanding is you did have a chance to go over that before I came out here initially with your lawyer. Is that correct?
Yes.
Mr. Reardon, is that accurate? Did you review that with Mr. Edmondson, read it over with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, he did.
Is that correct, Mr. Edmondson?
Yes.
So you understand what the document says?
Yes.
Do you have any questions for me about what it says?
No.
All right, well then, if you want the court to accept your plea, you need to sign that document at this time.
You're right, isn't it? Yes.
Yeah, it's the other one. You can have it if you want.
So you sign this document, Mr. Edmondson?
Yes.
Very well, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. And I'll find the defendant guilty. No, I'm not going to find the defendant guilty. I'll accept your plea to count 1 and 2, possession of cocaine, felony to 5th degree in violation of 292511 of the revised code, each with a forfeiture specification. At this time, I will grant your motion for intervention in lieu of conviction. I'm going to stay all further criminal proceedings, which includes finding you guilty and sentencing. I'm going to place you under the supervision of Lake County Adult Probation Department for a period of 2 years. And I'm going to order the implementation of the following intervention plan. I'm going to order that you serve 85 days in jail. You have credit for 39, so there's 46 more days. I'm going to order that you immediately get into the jail treatment program and successfully complete that program. Follow all aftercare recommendations. I basically gave him the bare minimum amount to get through that program, but if he does get through it sooner and he's completed it, you can let me know and we can vacate whatever balance there is if he does get out. Again, follow all aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. That includes no marijuana. It doesn't matter if you have a marijuana card or not. You're not to use marijuana, cocaine, or any other drugs. You have to submit urine screens when requested. They have to be negative. Positive screen will be a violation. You can't screw around with the urine sample, bring in fake urine, someone else's urine, anything like that. You're to attend 3 AA meetings a week and have a sponsor. You're to obtain and maintain full-time employment. I don't care where it is, but you need to be honest about it and provide proof of it. Pay your court costs and supervision fees. I'll order the forfeiture of the contraband and instrumentalities. I'm going to have you complete the decision points program also. That's something else that you'll be able to do while you're in there. So you're going to be keeping busy while you're in the jail there. That's a good program that helps you make good decisions and right decisions. Now, I've noticed, as I alluded to at one point, your traffic history is not good. Your license is suspended. Why is your license suspended?
Failure to reinstate. I was on a reinstatement program. I paid $25 a month to keep it.
Well, I'm going to order that you make a reasonable effort at obtaining your driver's license. Obviously, that's something you want to do, and it's going to make your life a lot easier. But I'm going to I'm not suspending your license. That's been, whoever did that. But you are not to drive without a valid license. That's a condition of your intervention plan. So if you get caught driving, like you were this night, even if you don't get charged with DUS, you violated your probation. You understand that? Mm-hmm. So no driving a vehicle without a valid license. I mean, if you were to get privileges somehow, then you're valid. Or with valid privileges, I'll say that way too. I don't know if that's something that's possible to get, but no driving a motor vehicle without valid license or valid driving privileges. I can't give you privileges. It's not my suspension. But I'm not going to... Obviously, if you get charged with DUS, then you'll be actually committed a new crime. But if you don't get charged, it doesn't mean then you've gotten away with it, that you're still violating. You understand that?
Yes.
Jamie, anything else I should be thinking about for the intervention plan?
Nothing else, Your Honor.
So, Mr. Edmondson, you understand all the conditions of this plan?
Yes.
Any questions for me?
No, Your Honor.
All right, if you comply with this and work with probation, this case gets dismissed and you don't have a felony record. If you don't, I need to advise you what's going to happen is that we'll have a hearing. And if I find that you did violate, I'll lift the stay of criminal proceedings. I'll find you guilty of the 2 charges, and we'll proceed to sentencing where anything that I just explained to you could happen, which could include 2 years in prison. You understand that?
Yes.
All right. Mr. Reardon, anything else for the record?
Your Honor, I just wanted to ask, because it went by kind of fast. I didn't catch, I was writing, but the sentence included how many days jail and how many days credit?
85 jail with 39 credit.
Okay. And I just wanted to make sure that Mr. Edmondson understands that that means you're going back to jail today and you have a further 46 out there. But if I heard you correctly, he's going to do the jail treatment and this decision points program. And if for some reason he completes it sooner than 46 days, the court might entertain a motion from me to...
You won't even have to file a motion. Probation will let me know and I'll let them out.
You'll let, okay.
And it's just completing JTP. Decision points you won't finish in that period of time.
Oh, okay.
He'll finish that on the outside.
Okay.
So you don't have to complete decision points while you're in jail, but you're going to get started while you're in jail, and it gives you something more to do, and you're going to be able to knock at least half of it out, if not more.
Right.
JTP is a 30-day program. The minimum that we give someone is 45 days, because it usually takes usually we give 60 days, but a couple weeks is usually to dry out, which you've already been in for that, so I don't need to do that. So if you can get in sooner, and you can't control that, but if there's an opening, they'll get you in sooner, and then it's 30 days from then you'll be able to get out if you complete it.
And then he's to follow the recommendations that JTP gives him when he gets out.
Right, exactly. Exactly. You understand all that?
That's all I had,
Yes.
Your Honor.
Ms. Linden, anything else?
Just to make sure, I'm 2 years on each count,
Well, it's not probation.
so you're not, okay,
It's an intervention plan.
okay,
Yeah, don't put that for this one, just 2-year intervention plan.
thank you.
All right, thank you.
Thank you.
All rise.
Nice to meet you.
You may be seated. Mr. Downing.
Thank you, Your Honor. We are present this afternoon in the matter of State of Ohio versus Muhammad D. Salet. This is case number 25 CR 1549, present open court. This afternoon is the defendant with his attorney, Bill Watson. We were last here on December 8th of 2025. At that time, the defendant withdrew his previous entered plea of not guilty and put a plea to count 2 and count 5 of the indictment, both same code section, both felonies of the 5th degree. The remaining counts to be dismissed upon sentencing. Beyond the charges, there was no additional terms of the plea agreement. This court ordered a pre-sentencing court paid as a part of its plea that it would be recommending consecutive prison term. At sentencing today, the state did have an opportunity to review the pre-sentencing report and is prepared to proceed with sentencing this time.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. Mr. Salet, he's currently serving a prison sentence. I know the court's well aware of that. And I also believe he's been sentenced out of federal court. And that is to be served consecutively to what he's currently serving, I believe, out of Cuyotta County. And of course, he's here in front of this court today. Not to mention the fact that my client has a history. He's been to prison before. So he's, you know, Your Honor, he's certainly dug himself a hole in life doing things that he shouldn't have been doing. And when I first met Mr. Salet, he told me that he wanted to take responsibility for this right away, that while in prison, that he was signing up for programs, that he wanted to turn his life around, that he wanted to use his time wisely. And in fact, I believe he was supposed to start a program this January, right about now. He's still here, obviously, but you know, he has every intention, once he gets back to prison, to get back into these programs. Your Honor, I'm simply asking the court to consider the fact that he did take responsibility for this, that he is remorseful, and that I'm hoping that he's serious in what he says as far as wanting to turn his life around. I still think he's fairly young, and I still think he's got a lot of life ahead of him if he were to use his time constructively. Maybe he can learn something and get out and be a good law-abiding citizen. You'll hear from him in just a second, Your Honor, but I'm just going to respectfully ask the court to consider on the lower end sentence, understandably that it would be run consecutively with that, Your Honor, but give Mr. Salet an opportunity to finish out his time and be able to come out and hopefully be a better person. Thank you, Your Honor.
Thank you. Mr. Salet, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
First and foremost, I want to apologize to the company that was involved into this crime. I want to apologize to the county. I want to apologize to the courthouse for bringing these bad behaviors and actions upon all three parties. And hopefully I'll be able to get my life together and be blessed. And thank you. Have a nice day.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Mr. Downing for the state.
Thank you, Your Honor. As I stated in chambers, the particular facts of this case, although felony offenses, so by their nature they are serious, the particular facts of this case are not the most serious of the type of crime that we would see for this. There was no loss in this case. The crime itself was discovered relatively quickly by the members of the bank here because they'd had training on this. However, where the defendant runs into issues, as this court is well aware, is his lengthy criminal history and the fact that when he committed these offenses, he was wrapped up in other courts. He was already reported to report to federal prison that same month after serving a prison sentence, violating on release, and then being resentenced to prison. He also had a pending case in Cuyahoga County that he has since been sentenced on. So there was just an entanglement of criminal activity here that the defendant took a part in, this conduct in Lake County being one part of that. Although the facts of this case are not particularly bad, they are felony offenses. They are offenses that occurred separate in time and location than the rest of his criminal history that was pending at the time. So I do believe that there should be particularized punishment for that, separate from his sentence that he's currently serving now. And so I do believe consecutive prison terms in this case would be appropriate, specifically because they were committed while he was awaiting trial or sentencing or under sanction, and that his criminal history does show that the consecutive terms are needed to protect the public. As I stated, no restitution, and just asking for that prison term to be served consecutive. Thank you.
Thank you. This court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offenses. I've considered what's been said here today by all the parties. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, the court finds the defendant acted as a part of organized criminal activity. Nothing makes it less serious. As for recidivism factors, many of these are present. The defendant has a lengthy, extensive criminal history, juvenile delinquency adjudication starting when he was 13, in the DYS before, then as an adult, continued on. He's previously served prison terms before. He has failed in the past to comply with previous orders from courts. He's got probation violations. Nothing indicates recidivism is less likely. Under 29-29-13b1, the court notes the defendant previously served a prison term, committed the offense while he was on bond to another court. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, it will be the sentence of this court that on both counts 2 and 5, the defendant served a term in prison of 8 months. I'll run those 2 counts concurrent with each other, but that prison term shall be served consecutive to the prison term that was imposed in Cuyahoga County, case number 25 CR 698-718, as well as the federal sentence 17 CR 00063-SL-2. Court finds in this particular there's 3 days of credit. I'll give him the 3 days of credit that he had before he started serving any of these sentences. Court notes and finds that consecutive service is necessary to protect the public from future crime and to punish the offender. They are not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that he committed the offenses while on bond in Cuyahoga County. And this history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. Defendants further ordered to pay out costs. The balance of the indictment is dismissed as agreed upon. I think that covers everything. Anything else for the record, Mr. Downing?
No, Your Honor, thank you.
Sorry?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All rise.